Family Court Article 6. A proceeding for the commitment of the guardianship and custody of a child on the ground of permanent neglect is originated by a petition alleging that A. The child is under 18 years of age, B. The child is in the care of an authorized agency, C. The authorized agency has made diligent efforts to encourage and strengthen the parental relationship and specifying the efforts made, or that such efforts would be detrimental to the best interest of the child and specifying the reasons why. D. The parent or custodian, notwithstanding the agency's efforts, has failed for a period of either at least 1 year or 15 out of the most recent 22 months following the date such child came into the care of an authorized agency, substantially and failed to continuously and repeatedly maintain contact with or plan for the future of the child, although physically and financially able to do so. And E. The best interest of the child require that the guardianship and custody of the child be committed to an authorized agency or to the foster care parent authorized to originate this proceeding. Where the petitioner is not the authorized agency, allegations relating to the efforts of the authorized agency may be made upon information and belief. On the filing of the petition for permanent termination of parental rights, Article 6, the court may cause a copy of the petition and summons to be issued, requiring the parents to show cause why the court should not enter an order committing the guardianship and custody of the child to the petitioner for the reason that the child is permanently neglected. Service of the summons and petition for Article 6, permanent termination of parental rights, shall be made by delivery of a true copy to the person summoned at least 20 days before the time stated for appearance. If so requested by the parent or other person legally responsible for the child's care, the court may extend the time for appearance and answer. If, after reasonable effort, personal service is not made, substitute or service by publication, as may be ordered by a judge, shall be sufficient. When used in this part, Article 6, permanent termination of parental rights, fact-finding hearing means, in the case of a petition for the commitment of the guardianship and custody of a child, a hearing to determine whether the allegations required are supported by clear and convincing proof. Used in this part, permanent termination of parental rights, Article 6, dispositional hearing means a hearing to determine what order of disposition should be made for the best interest of the child, where the disposition ordered is the commitment or guardianship and custody. Only competent, material, and relevant evidence may be submitted in a fact-finding hearing. Only material and relevant evidence may be admitted in a dispositional hearing. So, in order for evidence to be admitted at a fact-finding hearing in Article 6, it must be competent, material, and relevant. But dispositional hearing only needs to be material and relevant. For the commitment of the guardianship and custody of a child, the court shall enter an order of disposition, either A, dismissing the petition, or B, suspending judgment for a maximum duration of 1 year, unless the court finds at the conclusion of that period exceptional circumstances require an extension for an additional extension of 1 year, or C, committing the guardianship and custody of the child, however, that an order of disposition committing the guardianship and custody of the child may not be entered after the child's 18th birthday unless the child consents. So, again, at the conclusion of the dispositional hearing on a petition for the commitment of the guardianship and custody of a child, the court shall enter an order of disposition, committing the guardianship and custody of the child, provided, however, that an order of disposition committing the guardianship and custody of the child may not be entered after the child's 18th birthday unless the child consents. And the maximum duration of a suspended judgment, Article 6, permanent termination of parental rights, is 1 year, unless the court finds at the conclusion of the period that exceptional circumstances require an extension for 1 year, but successive extensions may not be granted. Okay, so order of suspended judgment. The order of the suspended judgment must set forth these things. It must set forth A, the direction, terms, and conditions of the suspended judgment. B, must contain a date certain for a court review, not later than 30 days prior to the expiration of the period of the suspended judgment. C, it must state in conspicuous print that failure to obey the order may lead to its revocation and the issuance of an order terminating parental rights and committing the guardianship and custody of the child to an authorized agency for the purpose of adoption. And D, a copy of the order of suspended judgment along with the current permanency plan must be furnished to the respondent. Not later than 60 days before the expiration of the suspended judgment, the petitioner shall file a report with the family court, all parties, including the respondent and his attorney, the child's attorney, interveners, if any, regarding the respondent's compliance with the terms of the suspended judgment. The report shall be reviewed by the court on the scheduled court date. So, the suspended judgment is 1 year. 60 days before the suspended judgment ends, the petitioner has to file a report with the court, and file a report with the court, the parties, the child's attorney, interveners, regarding the respondent's compliance with the terms of the suspended judgment. And the review shall be within 30 days before the end of the suspended judgment. So the petitioner files the report 60 days before the expiration, and the court has the review 30 days before the expiration. A petition to modify a disposition in order to restore parental rights may be filed where the following conditions are met. A, the order committing guardianship and custody of the child had been issued 2 or more years prior to the date of filing the petition to modify it. B, the order committing guardianship and custody of the child had been based upon adjudication of abandoned for 6 months, or mental illness and intellectual disabilities of the parent, and the child had been in the care of the agency for 1 year, and permanent neglect of the child. C, the petition alleges that the petitioner and respondent in the proceeding in which guardianship and custody had been committed consent to the relief requested in the petition, or that the petitioner withheld consent to the relief requested in the petition without good cause. And D, the child is 14 years of age or older, remains under the jurisdiction of the family court, has not been adopted, does not have a permanency goal or adoption, and consents to the relief requested in the petition. A proceeding to modify the disposition in order to restore parental rights may be originated by the filing of the petition by the child's attorney, an agency or individual to whom guardianship and custody of the child has been committed, the respondent in the termination of the parental rights proceeding, meaning the mother or the father, the attorney who represented the respondent in the termination of parental rights proceeding. And the petition shall be served upon those same people: the child's attorney, the agency or individual to whom guardianship and custody of the child has been committed, the respondent in the termination of parental rights proceeding, and the attorney who represented the respondent in the termination of parental rights proceeding. A certified copy of the order committing the guardianship and custody shall be attached to the petition. So I'm just going to name those 4 people one more time. This is a proceeding in Article 6 to modify a disposition in order to restore parental rights, and who it may be originated by, who may originate it by filing the petition, and who it has to be served upon. So it's either 1, the child's attorney, 2, the agency or individual to whom guardianship and custody of the child has been committed. 3, the respondent in the termination of the parental rights proceeding. And 4, the attorney who represented the respondent in the termination of parental rights proceeding. Article 6, Part 1, Petition to Restore Parental Rights. The petitioner shall have the burden of proof by clear and convincing that restoration of parental rights is in the child's best interest. With respect to applications by grandparents for visitation or custody rights with a child remanded or placed in the care of a person, official, agency, or institution, the applicant shall serve a copy of the application upon the social services official having care and custody of the child and the child's attorney, who shall be afforded an opportunity to be heard. Service shall be in the manner court prescribes. The court may not conduct an in-camera interview of an infant in proceedings concerning custody unless a steno record is made. An infant is under 18. Infant is 0 to 17.